Good afternoon. My name is Steve Roth, Chair of Sutherland's Financial Services Practice. It's my real pleasure this afternoon to welcome you to the Sutherland webinar we're putting on this afternoon entitled Black Hats, Firewalls, and Data Loss, Insurers Confront Data Breach Litigation. I'm joined by my colleagues Tom Curvin, Phil Stano, Tracy Ledbetter, and Mark Thibodeau. This is our latest in a series of webinars devoted to issues faced by the insurance and financial services industry, the most recent being late in October, dealing with the Telephone Consumer Protection Act, the materials of which are found on our website. We'd like to welcome back those of you who have joined us for previous webinars, both the TCPA webinar and others, and we'd like to welcome those of you who are new to this series. If you'd like to receive CLE credit for this webinar, please download the CLE sign-in sheet and evaluation form from your viewing console and follow the instructions for submission. Should you have any questions during the webinar, you can submit them via the Ask the Question text box on your viewing console. We'll be monitoring those questions and try to fit them in to the extent we can, consistent with the flow of the webinar. Many of you, indeed maybe all of us, are asking whether hackers are taking over the world. Companies with iconic brands like Home Depot, Target, and Neiman Marcus have suffered catastrophic security breaches, exposing them to reputational costs and potential civil and regulatory liability. Insurance companies are also targets for hackers, and they face class action exposure as well as regulatory inquiries. Casualty insurers, property and casualty insurers, also face potential coverage exposure to the damages of insureds who have been the target of data breaches. We're here today to discuss all of these issues, and so with that, it's my pleasure to turn you over to Tom Curvin, who is the co-chair of Sutherland's Litigation Group. Tom?
Thanks, Steve. Well, data breaches are certainly in the news. It seems like it's becoming a holiday tradition, along with a Macy's Thanksgiving parade, Black Friday shopping, and then news of a blockbuster data breach last week against a major consumer products company. Today's focus is going to be data breach litigation involving insurance companies, and specifically, here's what we plan to cover during today's program. First, we want to give a quick overview to discuss briefly the magnitude of the problem. What sort of data breaches have been targeted at insurance companies, and how frequent have they been, and what's the exposure? So that's what we'll cover first and briefly. Next, we want to shift and discuss litigation developments involving insurance companies who themselves have been the targets of data breaches. Insurance companies have been targeted by hackers and other nefarious actors, and not surprisingly, litigation has ensued, including, in particular, some significant class action litigation against insurers. So that's what we'll cover second. Third, we want to shift and discuss litigation involving cost shifting. That is, when targets of data breaches themselves then turn to their liability and casualty insurers to try to shift or recover some of the costs. There's been a significant amount of coverage litigation percolating through the court system, and we're going to touch briefly on those issues. And then finally, and related to the cost shifting topic, we're going to briefly touch on the insurance market's reaction to the data breach litigation and data breach exposure by briefly discussing some specialized new cyber liability policies that are out there and may be of interest to this group. So that's what we hope to cover today. And with that, let's start with a brief discussion of the magnitude of the problem. According to a well-known nonprofit clearinghouse, from 2005 to early December of this year, there have been approximately 590 and now close to 600 known data breaches that have been publicly reported data breaches involving companies in what this clearinghouse calls the financial insurance and insurance services sector. So close to 1,600 publicly reported known data breaches against insurance and financial services companies. That's just since 2005. Who are some of the targets of these data breaches that have been publicly reported? in the insurance industry. Health insurers have been frequent targets of data breaches. Life insurers, disability insurance companies, workers' comp insurers, auto insurers, homeowners insurers, title insurers, municipal bond insurers. All of these types of insurance companies have themselves been targeted with data breaches within the previous few years. In addition to insurance companies themselves, there have been a lot of affiliated companies in this space who have also themselves been targeted. One prominent state health insurance exchange just set up under the Affordable Care Act within the last couple of years itself has already been targeted. There have been data breaches targeting wholesale insurance brokers. There have been data breaches and schemes targeting independent insurance agents along with captive agents. There have been data breaches targeting independent adjusters. And just by way of perspective, many prominent state and federal regulators have themselves been hit with data breaches. FINRA, the agency that regulates many aspects of the securities industry, they were targeted with some laptop thefts, very highly publicized. The SEC itself, the Securities and Exchange Commission, was the victim of one high-profile data breach. The New York State Banking Department and the South Carolina Department of Revenue have also been targeted with data breaches. So as you can see, this phenomenon is widespread. The numbers of these incidents are certainly on the upswing, and the trend is toward more targeting and, frankly, more sophisticated targeting. So with that, Mark Thibodeau, give us an idea of what sorts of attacks are we talking about in which insurance companies have been targeted?
So everybody's no doubt seen the headlines about retailers that have been hit by hackers, and it's making news with increasing frequency that breaches are happening. But insurance companies, although not a lot of those get publicized, are facing attacks as well, and those range from your traditional hacking sort of attack where if you picture a hacker sitting in some dark room or a basement of the computer trying to break into your system, that still happens, although increasingly, as we'll talk about a little bit later, some of those people are wearing military uniforms now. You have attacks that are called phishing, and phishing is simply an email that appears to be a legitimate email, but actually ends up being something else, having links in it, for example, that if you click on them will install malicious software on your computer, or which take you to a website which looks like a legitimate website but turns out to be something else entirely. A constant recurring theme, particularly for the insurance industry, is laptops that are either lost or stolen. It's really inexcusable in this day and age that anybody has laptops that do not have their hard drives encrypted, but it still does happen. And the general rule of thumb in the hacking community is if they can touch a computer, they can break into it, meaning just having a password required to log on to the computer is not sufficient protection. And then you have servers that are stolen out of data centers. You've got backup tapes that are stolen in transit or lost in transit, and good old-fashioned fraud or employee dishonesty. And then in addition to these, what's not on the slide is the fact that there's still an awful lot of data breaches that occur simply from mistakes happening. Emails being sent to the wrong addresses, packets of information being mailed to the wrong address, or misconfigured computer systems.
Yeah, and Mark, I would add that from publicly available information, we can confirm that insurance companies themselves have been targeted with every type of attack you've just described.
And to kind of drive the point home, what this slide here shows is actual screen capture from an underground website on the internet of a hacker group trying to sell information that was stolen from an insurance company. For those of you not familiar with hacker lingo, where it says FULZ, F-U-L-L-Z on the slide, that means a complete healthcare record from an individual from an insurance company. And as you might see from the bottom of the slide, they're going from anywhere from $8 per record to, in bulk, $6.40. Compared to credit cards in situations like Target and Home Depot, credit cards are generally only selling for about 50 cents to $1 a piece. So healthcare records stolen from insurance companies are a lot more valuable to hackers. The sources of attacks that I alluded to earlier are coming from a variety of places. It's no longer some bored teenager in his mother's basement hacking into your systems, although that still occurs occasionally. But it's gotten a lot more sophisticated, and Richard Clark, the former White House cybersecurity czar, came up with this acronym CHEW to describe the actors in this space as being criminals, hacktivists, people like Anonymous and other organizations that want to break into systems in order to embarrass companies or try to make it hard for them to do business. Espionage, either industrial espionage from your competitors trying to find out what you're doing, or foreign governments trying to give their state companies an advantage over U.S. companies in particular, but European companies as well. And then out-and-out warfare. There's been incidents. Last year, the U.S. government indicted 6 members of the Chinese military for hacking. There's been rumors that the Syrians and Iranians are involved in hacking, and you may have most recently heard stories about Sony Pictures being broken into allegedly by agents of the North Korean government. The root causes of data breach basically boil down to one of 3 sort of things: a malicious attack, a system glitch, or human error. And what this slide illustrates is, and this is data from the Ponemon Institute, which is a consultancy run by a former PricewaterhouseCoopers partner that does a very good job of collecting data in this space. What it shows is that glitches and human error still account for more than half of the data breaches that are occurring, but that's certainly not to say that malicious attacks are not a significant factor. And the malicious attacks end up being the most costly ones. I don't know that I necessarily believe the numbers that Ponemon publishes on this sort of information, that it costs $159 per record lost on average when a hacker breaks in, but the costs can certainly be significant. And this is just for publicly reported breaches, which tend to be the worst ones.
So we've got a sense that really all sectors of the insurance industry have been targeted with data breaches of many different types and by many different elements, criminal and otherwise. And the numbers of these incidents tend to be on the upswing, so not surprisingly, litigation has followed. So we want to shift gears and talk a little bit now about what sort of litigation has been brought against insurance companies arising out of data breaches in which insurance companies themselves are the targets. Phil?
Thanks, Tom. Tracy and I are going to talk about litigation involving life insurance companies, and we can't do the subject justice because of the time limits, but we want to give the audience a flavor of what's out there. Despite the seemingly exotic nature of data breach litigation or cyber litigation, the causes of action involving these cases are very familiar. Some would say they're depressingly familiar. You take the same causes of action and you put them in a different setting, and the setting involves the damage is not the denial of a claim, it's breach of privacy, it's exposure of confidential information, it's identity theft. So it's really the same concepts, the same theories, and I'm sure that every counsel on this call looking at the screen is very familiar with all of these causes of action. So you're just applying it in a different setting. And you will see state statutory violations that you may not have seen before, the notification statutes, which we'll talk about real quickly. You almost always will see a negligence cause of action, and the negligence is usually based on either the inadequate system that you have in place to protect the privacy of your customers, the fact that you may have turned off a protective device when you should have left it on, or maybe the company was allegedly slow to respond or to react to a data breach. It's that type of fact situation, fact scenario, and causes of action that you'll be running into. Other causes of action are on the next slide. Again, these are statutes that you're very familiar with, HIPAA, Gramm-Leach-Bliley. The most concerning development that I see is the parens patriae claims by state attorney generals. They're concerning because you cannot remove these to federal court, and they, in effect, are a class action that will stay in state court. And the AGs are increasingly turning to their plaintiff lawyer allies to reward them with these cases as a payback for assistance in the attorney generals in their elections. And this is something that I think the industry will face increasingly in the future.
Phil, I would add one point to that. I agree with you that those are really risky areas because state attorney generals, in addition, are not limited by some of the traditional standing doctrines that may make it difficult for a private consumer whose records have been accessed to sue. These parents patriae actions are really dangerous for the industry because the state attorneys general, they have options available to them that private litigants may not. So I would echo that as a big concern.
Yeah, Tom, I see it as a weapon that the plaintiffs' bar and the plaintiffs-oriented state AGs haven't fully discovered or implemented yet, and I think it's just a matter of time. You also have state notification statutes that you will need to comply with, and violation of these statutes can only add to your alleged damages or damages to the class and add to your misery. As of 2012, as we know, 46 states and D.C. have these statutes, but it really doesn't matter because Texas has a statute that says that you need to notify everyone who resides in the state whether the state has a law that requires notification or not. So that's something you'll need to look at, and oftentimes these statutes will throw a curveball at you because some statutes, for example, say that you can delay notification if you're assisting in trying to solve any crime that may have resulted as a result of the breach. And then you're caught between, do you assist law enforcement to try to solve the crime or do you give notice to your customers? Sutherland has already successfully defended one case like this, and we'll talk about it in just a moment where that issue came up.
And just briefly, Kentucky has now joined the fray to make it 47 states this year.
Okay. My slide's out of date. Cases against insurers, basically the cases that we want to talk about break down into two categories. The first category is where the plaintiff cannot allege actual harm. In a situation like this, you'll want to move to dismiss as soon as you can because it will help you if you can argue they don't have standing, there's no case or controversy, because the longer the case persists, the greater the chance that they'll be able to amend their complaint and allege that they've been damaged in some way. And there are a list of cases there that Tracy's going to talk about in a little more detail. And then there are also cases where plaintiff can't allege harm or all the harm they allege is emotional distress. The courts have not granted the motions to dismiss. And so the courts are, as you would expect, are split on this. Tracy, do you want to provide a little more detail on how the courts are addressing these issues and what their rationales are?
Sure. Thanks, Phil. There's only been very few reported cases against insurers on these data breach type actions. In fact, these 6 are pretty much the only ones that we could find. So just talking about the cases that have been dismissed, first of all, the overall theme that runs through all these cases is that any harm alleged to the plaintiffs is speculative. There's been no actual injury, no actual identity theft. So the first case that's up here is the Randolph case in the District of Columbia. And this is a case where a life insurance company was serving as the record keeper for a retirement plan for employees of the District of Columbia. And an employee took some files from the company, took them home, and put them on his home laptop. These files contained personal information of plan participants, including their names, their addresses, their social security numbers. Unfortunately, after he took these files home and put them on his home laptop, his home was burglarized and the laptop was stolen. And this was his home laptop, so it was not encrypted, it wasn't password protected. But there was also no allegation that this was anything more than a common burglary. So there was no claim that his home or this laptop was targeted specifically because of the information that it contained. The plaintiffs in this case couldn't allege that they'd actually suffered identity theft because they hadn't, but what they alleged was that they were at increased risk of identity theft, that they had to pay for additional credit reports or credit monitoring as a result of this data breach. And one sort of unusual thing is that because this was a retirement plan for District of Columbia employees, some of the plaintiffs were police officers in the District of Columbia, and so they had some concerns about safety because now home addresses of police officers were available, potentially, to criminals. In this case, the court found that the plaintiffs didn't have standing because simply the increased risk of identity theft, the inconvenience of having to monitor their credit, was too speculative and conjectural to constitute injury in fact. It wasn't certainly impending harm. So the court dismissed the claims, and because it no longer had jurisdiction as a federal court, it remanded to the District of Columbia Superior Court. And on remand, the plaintiffs amended their complaint and added a few more causes of action, but again, the court dismissed. And on appeal, the Court of Appeals here in the District of Columbia decided to look at whether plaintiffs had stated a claim and not just whether they'd had standing. But again, the court found that to state a claim, the plaintiffs couldn't just show that there was some speculative harm out there that had not yet been realized, which was all that plaintiffs had alleged. The court noted that there wasn't any allegation that any plaintiff's identity was stolen or used, and as for the police officers, there was no allegation that the police officers' home addresses were revealed or threatened. And you'll notice that this is about 3 years after the breach, so you'd think that if something was going to happen, it would have happened by this point. So the Court of Appeals found, as to most of the claims, that the plaintiffs hadn't stated a claim. Specifically to the privacy count, this will come up in a few of the cases, but the courts dismissed the invasion of privacy count because the plaintiffs weren't able to allege anything about what had happened to the data. So they couldn't allege that somebody had accessed the data, that somebody had looked at it, that it had been publicized. And the court said, this thief might not have known there was data, this type of data on the laptop, and just wiped the hard drive without ever looking at it. So there was no access or public disclosure that would be required to show invasion of privacy. About a year later, another company had a different type of data breach, and this is something that could really happen to any company. It's not specific to an insurance company, but this happened to be an insurance company whose job application database was somehow hacked. And it's not clear how this breach occurred, but the company found out about it when some of its job applicants started to receive phishing emails that appeared to be from the company. And so they realized this must have happened. Interestingly, the plaintiff in this case didn't actually receive any phishing emails, which will come up later. But the job application database here contained email addresses of about 450,000 applicants for jobs with this company. It also contained Social Security numbers for current and former employees, and it contained Social Security numbers, phone numbers, addresses, and employment histories of people who had received job offers from the company. But as I said, the plaintiff himself couldn't show that his information had been accessed at all. The company was not able to verify that. The company did tell him that his information in this database included his name, address, Social Security number, date of birth, phone number, email address, and employment history, but they couldn't tell whether the breach had included access to this data. So the court in this case dismissed because although an increased risk of harm could be a sufficient basis for injury in fact, and therefore for standing, there had to be a credible risk of harm. And in this case, that wasn't shown, or that wasn't alleged, because there was no allegation of access, and the only information that apparently was accessed in this breach was email addresses. And the court commented that since the plaintiff was now aware of this phishing issue, he probably wouldn't give away his personal information if he received a phishing email. So again, the court dismissed this case against the insurance company. The last case involving a claim against insurers involved a hacking incident into property and casualty insurer's computer network. And this network contained personal information of people who had purchased insurance from this company or had sought quotes for this type of insurance. So the personal information included things like names, and it could include social security numbers, driver's license numbers, birth dates, marital status, gender, occupation, and the person's employer's name and address. The plaintiffs claimed that they had been harmed in basically three different ways. There was an increased risk of identity theft, and they had to expend costs to mitigate that risk. They'd suffered an invasion of privacy. And they also alleged that they'd been deprived of the value of their personal identifying information. But in this case, they hadn't actually had any identity theft issues. The court dismissed the claims because the injury wasn't concrete, particularized, or actual or imminent. And it also wasn't fairly traceable to the challenged action. In most cases, the plaintiffs couldn't show injury in part because the harms weren't imminent or certainly impending. It was just a sort of possibility out there in the world. The court also commented that the risk of future injury depended on criminal acts by independent decision makers. So it would depend on third parties doing something bad with the data, and the company wouldn't be responsible for that. The court also commented that the plaintiffs couldn't just create standing by choosing to make expenditures like credit monitoring or identity theft insurance just to mitigate a harm that was still purely speculative. And in terms of the claim for value of the personal identifying information, this actually isn't the first time this has come up. But in this case, the court said that there wasn't any actual loss of value because the plaintiffs didn't allege that they were somehow prevented from selling their data on the black market, although they didn't allege whether they even had access to the black market. So, they hadn't lost the opportunity to sell their data. And the plaintiffs also didn't allege that a third party had sold their information, and therefore the plaintiff had been deprived of their rightful profit in the personal information. So in this case, the court found that, or dismissed that claim. As to the invasion of privacy claims, again, this is an issue that comes up quite a lot, not only against insurers, but in coverage situations. In order to state a claim for invasion of privacy, one of the elements is publicity, so public access to the information. And in this case, the court found that there was no evidence of public access, and the court also found that there's no evidence that the company, as opposed to hackers, had disseminated the plaintiff's information to the general public. And this comes up as well in the coverage cases where some courts have come up with different conclusions on that question of publicity. So turning now to a couple cases against insurers have actually survived motions to dismiss. And these are a little bit puzzling in light of the other cases in which courts find that harm is speculative. In particular, this Roe case is puzzling to me. This case is against a health insurance plan provider. And in this case, the company somehow accidentally posted personal information online. So this is not really a hacking type situation, but just somebody made a mistake. The personal information included members' ID numbers, which could include their social security numbers, and it also included medical and pharmaceutical information of members and their dependents. The court, in reviewing this claim, took a very liberal view of pleading standards. So even though the plaintiff didn't allege that any of his information was stolen or even that anybody had access to his personal information at all, the court simply inferred, for purposes of the motion to dismiss, that his information had been accessed. So having drawn that conclusion, the court allowed the Fair Credit Reporting Act to go forward. In this case, the court also addressed the issue of personal identifying information and whether that had lost value, and the court found that unlike in Galeria, in this case, the plaintiff didn't show that he had an interest in his personal identifying information, and the defendant didn't show that he didn't have such an interest or that it didn't have value. So the court sort of left that issue for another day. But unfortunately, that issue was never really resolved because after the motion to dismiss was denied, the case then settled. And essentially, there was a $3 million settlement fund and an award of about $500,000 in attorney's fees. And the last case I'm going to talk about is another one where the court denied a motion to dismiss. And this, again, happens to be against the health plan. And this one happens to be a stolen laptop, this time stolen from the company's corporate offices. And the laptop contained health information, social security numbers, names, addresses, and phone numbers. And in this case, it's more understandable. In this case, plaintiffs actually suffered identity theft. So one person had a bank account opened in her name, had credit cards activated and used, and had her home address changed with the U.S. Postal Service. And the other plaintiff had an E-Trade account opened and then overdrawn in his name. And again, the courts here gave a somewhat liberal reading to the allegations of the complaint when it was addressing the issue of causation and whether plaintiffs had alleged causation sufficiently to state a claim. There was a dissent in this case, and the dissent believed that it was equally conceivable that the identity thieves got this information that they used from some other third party as opposed to this breach. There was no allegation that only the insurer had this type of information or that the type of information stolen from the insurer was used to open these accounts. But that was a dissent, and the court affirmed the denial of the motion to dismiss, and the case again settled. Coincidentally, the settlement fund here was also $3 million, but these attorneys received an award of $750,000 after the motion to dismiss was denied. So in light of those cases, Phil's going to talk a little bit about a case study, a claim that he had actually handled against an insurance company.
Thank you, Tracy. Sutherland has actually defended one of these things, successfully defended it to conclusion, and there were a good number of lessons learned from this litigation. For those of you who are around in the 90s in the insurance industry, you may recall the class action litigation that just started involving improper replacement of insurance and vanishing premiums. And there was so much litigation. I remember attending an ACLI meeting and someone said to the audience, every one of you will eventually be a member of a settlement class one day. And that probably has turned out to be true for many of you. And so I think it's safe to make a similar prediction here. Everyone on this audience and in this room will one day be part of a settlement class involving data breach. And that also is an easy prediction to make because based on the, just from press clippings and from cases that we've seen, over 100 million Americans have already had their data breached. So that's approximately a third of the country, and we're just getting started on this new genre of litigation. The Edwards case, and we're only using the plaintiff's names, as you may have noticed. We're not using the company names, and is good for a lot of lessons, one of which is no matter how you think your data breach will occur, it will probably happen in a different way. The facts in Edwards were fairly straightforward. They're not complicated at all, and it's probably typical of a lot of the practices among the insurance companies. The insurance company's subsidiary had hired a vendor to assist in workers' comp claims. The vendor was located in an office building that had guards, lights, and was locked at night. The vendor was in an office suite in the office building, which was locked. And the vendor's data was kept in a server room that was also locked. That's relevant because the vendor was burglarized. The server room door was pulled off the hinges. It was a fairly stout door. And despite all that, the plaintiff sued claiming that, and a tape was stolen with plaintiff's information on it, supposedly, Social Security number and medical information. Plaintiff sued the vendor and, of course, the insurance company, claiming that the vendor was negligent in maintaining the data and that the insurance company was negligent in hiring the vendor. So no matter what you do, you're going to get a negligence claim. I can guarantee you that. A very interesting case in that the allegation, it was a California case, state only, in state court. The judge took a heck of an interest in the case. It was his first data breach case. He was very interested in it and actually was fairly good and fairly even killed about it. We moved for a motion. We filed a motion to dismiss immediately, and that's something I would recommend if you have any cases like this, because plaintiffs may not always have alleged damages because maybe they haven't experienced any yet. And plaintiff immediately amended their complaint when we filed our motion to dismiss, but still had not been damaged and said everything they could say without saying they were damaged in any way because they hadn't experienced any damages. So we had a strategic advantage by moving early. The damages in the case, as you can see from the slide, were quickly mount up. Now, how did plaintiff find out about this? Well, California has a notification statute. We sent notice to the plaintiff, and that's what caused plaintiff to file suit, even though he had not been damaged. Plaintiff's stick in the case to try to force settlement was the alleged damages, the exposure to the company. Our stick in the case was you could not show the injury, you could not show causation, you could not show negligence on our part because of the facts of the case, and so it was sort of a standoff. We eventually, in the next slide, we'll show some of the defenses we argued. We argued lack of causation. We argued lack of standing. Despite the case you may have, or these defenses, this typical fact situation will exist in whole or in part in your case, most likely. Now, plaintiff has damages, and you've got a different scenario to deal with. Plaintiff eventually alleged damages, didn't do any good. We forced settlement, and we were able to settle on a very favorable basis to the company. What this case shows is that the data breach you may have or eventually will have will come from unexpected corners. It will come with, it will be arise in a way that you may not be able to predict and may not be able to prevent.
All right, thanks, Phil and Tracy. So that's a high-level view of the key data breach litigation that's out there against insurers to date. And obviously the cutting-edge issues seem to be standing and the ability to prove that the class plaintiffs have actually been harmed as opposed to simply having someone with potential access to their information. And we'll continue to watch those cases as that area of the law develops. So we want to transition now into a related topic, and that is we've been talking about insurance companies as targets of data breaches. Well, the other significant area of litigation concerning insurance companies in this area right now is when insurance companies provide insurance to policyholders who are themselves the target of data breaches. Policyholders get hacked, and then policyholders want to look to their insurers to spread the risk and to try to recover some of the policyholders' actual compliance cost and potential civil liability by going after insurance companies. So that's going to be our next focus, and that is what sort of coverage litigation is out there involving insurance coverage for data breaches. And Mark, tell us a little bit about what's at stake here. What is the money that's at issue when policyholders are hit with data breaches that they through litigation might try to recover through insurance companies?
Sure, Tom. And as a brief sidebar to digress a little bit, if I might, I want to point out that a lot of cases that Tracy and Phil were discussing didn't involve traditional sort of hacking incidents. They were either accidental exposures or stolen laptops or stolen equipment. And I just want to caution anybody who's sitting out there thinking, well, we've never had a security incident before, so we don't have anything to worry about, because a very prominent security consultancy has said that the victims that they've assisted in cyber breach incidents have had an average of 243 days between when the breach actually occurred and when they first became aware of the incident. So a lot of breaches are being discovered by third parties, in many cases law enforcement, and at least one of my clients was first made aware of a breach that occurred on their data systems by the press release that the Department of Justice issued in indicting two individuals for committing the crime. So you don't think because you haven't heard about any problems at your organization yet that you don't have problems at your organization. But going into what sorts of costs companies are claiming for against their insurance companies, of course it includes the cost of doing the investigation itself to try to figure out what occurred and how to stop it from occurring again. Depending on how well prepared a company is in advance of an incident, that may involve trying to find somebody very last minute and therefore at premium rates in order to help them out with determining what had happened and how to fix it. Costs of notification of individuals if the type of data that was breached is data that requires notification either under federal or state law, or just because the company thinks it's a good thing to do to notify their customers of the fact that the customer's information was breached. I get questions all the time from companies about whether they should notify customers when a breach has occurred, and my default answer is always yes, because it's the right thing to do, not necessarily because the law requires you to do it. But those can be costly because in many states the required notification has to be sent via mail rather than email, and so tracking down, making sure you have everybody's latest address and getting them notified can be a painful and expensive process. On top of that, of course, some companies incur PR or public relations or media relations costs as well involved with an incident, and some companies will try to claim those expenses as a covered cost in this sort of situation. Many states have now gone as far in their breach laws as to require credit monitoring be offered to the victims of data breaches at companies. And so that's not a cost-free situation either, and companies are frequently looking to insurance companies to help them cover that cost. And then there's regulatory fines and penalties. HIPAA obviously has statutory penalties in place for breaches. Some state breach laws bring that into play as well, either for just the breach itself or for failure to notify on a timely basis. And then the FTC has increasingly been stepping into this arena as the federal cyber cop of last choice. They've been using their power under the FTC Act to say that data breaches constitute either an unfair or a deceptive trade practice, either unfair because you didn't adequately protect the information of people who expected you to give it better protection, or deceptive because you said on your website, we're going to protect your data, and then you didn't do it. And so the FTC has entered into consent decrees with a large number of companies now, many of which require 20 years of ongoing security audits and monitoring. And again, that's an expense that a company is going to look to try to recoup from somebody else if they can. And then, of course, the damages in civil litigation can be potentially significant, assuming the case survives the standing challenges.
So that's what is at stake when companies are targeted with data breaches, and not surprisingly, being rational business actors, many companies are looking to whatever insurance they might have to try to pay some or all of their liabilities and costs associated with their own data breaches. And there has been a good deal of coverage litigation involving these issues in recent years, in particular as data breaches proliferate. So I want to give you an overview of what some of these coverage issues are that have been kicking around through the court system. And first of all, what sort of insurance policies might apply when the target of a data breach was looking to its insurance companies to possibly spread the risk and the exposure. And there's litigation involving each of these types of policies that we'll talk briefly about. First of which is first-party coverage, business property coverages. These are typically, they provide protection against or coverage for direct physical losses. So, for example, if a company itself, if its own network is hacked, perhaps there's damage to its servers or laptops or other actual components of its network, it might look to its first-party property coverages. The next one is the commercial general liability policies, and this is where the real momentum seems to be right now in the coverage litigation. So a company is targeted with a data breach, and a company then pays out costs and perhaps even civil judgments or liabilities or settlements, and then looks to its CGL carriers. Related to the CGL policy are personal and advertising injury coverages. Those are often part of a traditional CGL business policy. They may also be endorsements to a policy, but there's been a lot of litigation involving personal and advertising injury coverages. And then also employee dishonesty and fidelity bond policies are implicated when the hacker or the thief or the bad actor is actually an employee of the target itself. So all of those policies are at least implicated when policyholders are targeted with data breaches. And as I mentioned, the CGL, the Comprehensive General Liability policies, those have been the focus of much of the litigation and the case law to date. Now, a typical CGL policy will, under the liability coverage, will say something like, we will pay sums that our policyholder becomes legally obligated to pay as damages because of bodily injury, property damage, personal injury, or advertising injury to which this insurance applies. And so that language is really the focus of the litigation that we've seen to date. Some of the key issues that are kicking around the court system is, what does property damage mean? And property damage, most courts say it's physical injury to tangible property or loss of use of tangible property. So obviously, when you're talking about something like a data breach, a big issue in the litigation is the type of injury that is implicated when someone's network is hacked, for example. Is that property damage? And the issue which has divided courts, frankly, is computer software and the data that resides on a server. Is that tangible property, or is it something intangible? Several courts have said that data itself is not tangible property. So personally identifiable information or customer records that are hacked and accessed, I think most courts have come out with the view that itself is not tangible property, and so there's not coverage by reason of liability for damage or for property damage. However, related to that, where courts have found that computer components themselves have been damaged, a server has been physically damaged, much less a laptop stolen, that most courts have concluded that sort of injury does constitute property damage and may in fact create coverage obligations under a traditional CGL liability policy. The other key coverage issue to touch briefly on is, again, you go back to most CGL policies provide coverage when there is liability for personal injury. And the real cutting edge issue here is, when can someone show that there has been personal injury by virtue of the fact that their personal information has been stolen? Tracy mentioned earlier that this has been an issue in some of the class action litigation where consumers whose personal data has been stolen have difficulty showing that their personal information not only has been stolen, but it's been accessed and used. That actually has significant coverage implications. In fact, the key issue in this area on the coverage, for the coverage question, has been if all that can be shown is that the data was stolen, is that enough to create coverage under a liability policy? Most of the courts have said that there must be something more than that. There must be that one must show that the data was actually accessed in order to show that there's been a publication within the meaning of your liability coverage. A couple of courts more recently, however, have said that access can be inferred. And so that's an issue that frankly is dividing courts right now. That if a company pays money to settle claims because its customer data has been stolen, is that enough to trigger their liability coverage without something more, without actually being able to show that not only was our customer's data stolen, but it was actually accessed and indeed published. So that's a cutting edge issue there. Before we shift gears, a CLE announcement. For those on the call who want to receive CLE credit for today's webinar, our confirmation code is December, the month of December. So when you sign in, when you use the sign-in sheet that's available for download, please enter the confirmation code December. Okay, so we've talked a little bit about coverage issues that are kicking around under traditional casualty products, such as commercial general liability insurance, and indeed the fact that in many instances courts have concluded that there was not coverage available under these traditional products. That has led the industry to respond with coming up with additional and more novel products to fill the gap. And so, Phil, we're going to shift gears and briefly talk about some of the newer policies that are coming online that actually provide specific targeted coverage for cyber breaches.
Thanks, Tom. The question of whether a data breach is a physical or personal injury is fairly simple. If you're the insured, it is a breach. It is an injury. And if you're the insurer, it's not, if you're the general liability insurer. Let's talk about coverage from the perspective of the insured. You're looking for coverage. You're not sure if your general liability policies provide this type of coverage, and even if they do, you're not sure if the coverage is adequate. You're in the market for some cyber risk coverage. What are you looking for? And how much do you buy? Well, of course, that's going to depend on a host of factors, and we can't get into that now because it's too complex of a question. But you're certainly looking for coverage for network and data security breaches, the regulatory investigation that's going to follow, and also for any judgment or settlement. The question is how much liability do you want? How much coverage do you want to buy? The figures are all over the place. I'll give you one example, and I'm not saying this is the gold standard or this is what you should follow, but it's just one way to try to get a hands on how much coverage you might want. In 2011, according to certain studies, a single data breach would cost $194 per electronic record, and even that figure is subject to debate and discussion. But if you were to go with that figure, $200 a record, for 50,000 records, you want $10 million in coverage, and that gives you an idea, a very rough idea of what type of coverage you would want.
Although apparently in volume the costs go down because Target in their third quarter report said their cost to date for dealing with the breach were about $248 million, and they actually have a receivable for insurance of $90 million on their books as well.
Yeah, for about 100,
for roughly 70 to 100 million individuals.
Right. So there's volume discounts available. And another issue is what's your coverage date? Typically for a life insurance policy, for example, it would be from day 1 to day 365 if you were to purchase it on an annual basis. Oftentimes these policies provide a retroactive coverage date and that's something you would want to look into and seek out because you may have already had a data breach and simply don't know about it. That's one of the attributes of these policies that don't necessarily exist with other coverages. In terms of the types of coverage you want, Tom, maybe the next slide. You would want coverage that for the steps that are involved to make the customer whole. And what we have here is a list of the steps that you'd want. And interestingly, the cyber risk coverage is akin in some ways to kidnap or ransom policies in that you can purchase coverages not only for what you would expect, what costs you would expect to incur, for example, notifying insurers who's suffered a data breach and providing credit monitoring, which also can be purchased in bulk and is very inexpensive, to restoring lost data, to also paying e-ransom demands, where you can seek out, you can pay the person who stole the data to try to get it back, or to try to give you the solution to the mess that they've caused with your with your computer or your data system. So the types of coverages available are varied. This slide here is meant mainly to put you on notice of what may be out there. And with the last slide, I would encourage you to use a broker who's familiar with cyber risk insurance, retain counsel who also has that same familiarity and expertise, and also be sure to look at policy exclusions, which is what you would do in any, regardless of the type of coverage.
Yeah, thanks, Phil. We actually have a couple questions that relate to this topic, and I think we have a few minutes left to cover some of the questions we've been getting. One question is, haven't carriers put exclusions on their current policies to limit these claims? And that goes back to certainly with what I will call, for shorthand, traditional liability and property policies, your standard business property policies, your standard commercial general liability policies. The answer is yes. Many of those policies, either in the policies or through endorsements, have exclusions to either entirely exclude these sorts of costs or to limit them. And employee dishonesty policies as well, you'll often find that the coverage limits for acts like this, and in particular for acts related to the theft of intangible data, that the coverage limits are quite low. And I think that reinforces the fact that those exclusions are out there and are so common has prompted the sort of non-traditional, more innovative products that
Right.
Phil has just spoken to. The market is reacting there.
Right. You look at your general liability policies first just because you have them and you see if the exclusion's there or not. And even if it's not there, you don't count on it. But then you go to the robust, growing cyber risk policy market.
And another question is, how does a provision in an NDA, a non-disclosure agreement, that transfers costs of investigation and damages related to unauthorized disclosure of data, how does that affect insurance coverage? That's actually a great question, and it again goes back to CGL policies. Most general liability policies contain an exclusion that says we're not going to provide liability coverage for liabilities that you voluntarily assume in a contract or agreement. And so I think that would be another example of where if you assume duties like that via a non-disclosure agreement, that would certainly implicate that exclusion under the liability policy. Professional liability policies, how those might respond to data breach. Professional duties to a law or accounting firm's clients. Again, I would caution that as a general observation, older, more traditional E&O policies, errors and omissions policies, and professional liability policies, if they have any sort of coverage for these sorts of issues, they're generally quite limited. Traditional casualty insurance policies contain either exclusions or very low limits for things, for injuries or costs associated with something intangible like a data breach. And again, I think that just reinforces why it is that the market is responding with newer, more innovative policies.
And as an insurer, under both HIPAA and Gramm-Leach-Bliley, you may have an obligation to make sure that your vendors are doing the right thing, including your law firms and accounting firms that audit you. And so you may have an independent liability even though the breach occurs there.
All right. Well, we've reached the end of our hour. I know that we have tried to cover a lot with you. This is obviously an emerging area of interest to the industry, and it's certainly working its way. These issues are working their way through the court system. With that, Steve, any final?
Yeah, we actually got a question very early on, a question about the disclosure of cybersecurity risks, noting that we're seeing that disclosure in mutual fund prospectuses. We're also seeing it in periodic reports that public companies are filing. The question being, will we be seeing that in variable product prospectuses? And I think the answer is likely yes, with the annual update season in 2015. I don't think there's much out there yet. Companies generally didn't include that disclosure in 2014, but we'll likely be seeing something of that sort in most prospectuses next year. I would like to thank everybody for joining us today. We appreciate your attention and your questions. we hope you have an enjoyable holiday season. We are going to have our next installment after the new year in this series on insurance and financial services litigation. We're going to be discussing big data, predictive modeling, and predictive analytics in the insurance world, both from a regulatory and a litigation perspective. So mark your calendars for January 13th, 2015, and we'll hope that you can join us then. Thank you very much.
Steve, I'll also say we had a lot of questions we did not get a chance to answer. We will get back to the folks who asked the questions.
Yes, thanks, Phil. Thank you. Thank you, everybody.
Thank you.
Have a good day. Take care.